So this video record I would like to make specifically for the European Court of Justice about the situation in Republic of Latvia and the government power offense with the use of court power without any existing reasons, and underage kid forced isolation with unreasonable restrictions over myself without ability to appoint legal consequences as described by law to the ones who actually were involved in such a government criminal power offense with use of various types of instruments and police force. That issue is lasting since 10th of August 2017, and it is not possible to solve it on a legal open way in local courts because the system and the court's power is built in a vertical way, so that systematic statuses or ranks would be taken higher than actual national legislation. After the court remedies in complete system of Latvia, there was an official petition applied to European Court of Human Rights with a complete proof base of the government power offense and the court deliberate pressures without follow-up of legal borders and national criminal law articles for which is stated strict responsibility, but it's not possible to realize because the systematic power and community relations are above power of law. The process in the European Court of Human Rights was going smoothly through the electronic contacts and instruments, but received court decision was about inadmissibility of the application based on in compliance with the European Convention regulations, articles 34 and 35. There was an appeal complaint sent to the court with the descriptions of the actual reasons why the mentioned articles and application in general was not possible to comply with such convention regulations because of the power offense at the first court instance violating national criminal law article. But that appeal complaint was not processed on a proper way because there were many restrictions in the public systematic uses such as post offices and many interested forces in this situation, that the case file would not be reviewed and the official outcome would not be appointed. There was information received about the reception of such a letter at the court by the telephone, but there was also official part received from the post office representatives about loss of such a registered letter in France. So that information is not complying with each other, but the main issue is that the court, European Court of Human Rights, is working within the conventions mentioned by that court regulations, and as I found it out, it is not so effective in reality over the other countries against which the petitions are applied, because of the fact that the case file was difficult to process because of various forces involved in discriminational purposes after the appointed crime with personal digital data outside the borders of country of residence in Netherlands during the employment agreement. There was appointed a steal of information and a share of such further in many countries, around about 35 countries at different levels, which caused a lot of disturbances and discriminational purposes, discriminational activities within the country of residence Latvia against me, just to keep that issue and crime, actual crime, out of the public, and many attempts to create various types of inconveniences or discriminate life using internal government and court systems without any existing reasons. And in this situation was used my underage kid for forced isolation and the restrictions of our legal rights. This kind of power offense, in accordance with the national law, is actual crimes. But the General Prosecution Office, which should be controlling such illegal activities, did not appoint legal measures for the court system representatives. So was also higher court instances as there is no actual effectiveness of the power of law in reality, due to the systematic performance and community relations above actual national legislation. I also turned to criminal collegiate of Riga Regional Court with these issues on official way, but even there was no actions taken in reality to prevent such a crimes with the use of court systematic power above national legislation or actual reasons. So the complete government system management and internal procedural order was gone through with no actual result in reality. That's why I conclude that all these activities were performed for forced loyalty to that system out of national legislation. In my opinion and a strong point of view, that legislation must be above any computerized systems, but such should be used as an instrument of realization of legal court activities within the procedural and criminal borders. Otherwise, each separate employee should be responsible for their straight activities in compare with national legislation. There were two petitions to the European Court of Human Rights about the son's permanent custody and the compensation for all created losses in amount of 500,000 euros because of all complete life was destroyed in electronic area registries and official use of government systems, and in real life using the court power and police power without actual reason was discriminated. That's the reason of inability to accept such system of management where the crimes are taken as managing as a managing direction for power keeping, illegal power keeping, for which must be appointed responsibilities. That environment for legal living and developments is not safe due to the fact that all of the information which was stolen during international crime is being shared into most of systematic management and political level too. I have no any doubts about the deliberate pressures were appointed by the political interests through the many contacts and television influence. I have actual proof about that in separate electronic devices, but that is very smart and quite a difficult instruments which are in possession of various influencers within the country of residence with further contacts in official organizations. Therefore, I would like to ask and request European Court of Justice to review the application and a bit of historical details in social networks which were created specifically for protection purposes in the internal system of management from the crimes in locked government systems. These records were made in 3 languages due to the reason of actual influence within the borders of Latvia, which is most powerful in public. That's the influence from the east, and in official organizations from European Union. If there is a chance for an open justice of directly involved personnel in my discrimination with official proof for such, and appoint legal consequences in respect of compensation for such a deliberate criminal pressures with the force of police and use of underage kid as an instrument, I would very appreciate if that can be done on open way, so that legal consequences could be shown as an example of why the as an example of legal borders for employees at official state organizations and level of legality of local courts, because they are all in the separate circles, which gives process, any official process above actual understanding of power of law. Structural order in recent system is officially on procedural way is very comfortable, acceptable, but the main issue is that if below structural organizations are violating or having some kind of interests in avoiding of performance of their state duties, these issues cannot be solved on official way. And attitude of the court personnel as a playground people for various aims is not enough competent for issuing or appointing legal consequences to involved personnel and private persons. Yeah.